Good night. This is U.S. Immigration Attorney Sharifa Tharp. I am live to take your questions. The question I'm going to be answering tonight is going to be, can U.S. residents apply for their spouse or their children in the United States? But let me remind you that I'm here to answer your U.S. immigration related questions. So go ahead and put your questions in the comments. I will answer them. Even though it's not related to the topic that I'm talking about, I still want to hear your immigration related questions. So, can U.S. green card holders apply for their relatives in the United States? And when I say relatives, qualifying relatives. So qualifying relatives are going to be spouse or children, either children who are under 21 and unmarried, or anybody who is over 21 and over and unmarried. Green card holders can't apply for parents, and they can't apply for married children. So if you are thinking about applying, or this is a question that you have, there you go, you have your answer. That outside of unmarried children and spouse, a green card holder can't apply for anyone else. Now, when they become a U.S. citizen, then they may have more options. So, hi, how are you? If someone gets married, can he apply for TPS anyway? Yes. So, I do have clients that are applying for TPS. So I've submitted their TPS application at the same time that they're applying for other benefits, because the TPS can serve as protection against deportation. It can allow the person to stay in the United States while their process is pending. So the two processes can go at the same time. Wingy09, thanks for the follow. Hi, how are you doing, Tamara? It's nice to see you. Thanks for asking, and I hope you're doing well as well. So, tonight I'm going to be talking about residents. So I was successful with my interview yesterday. Camps 356, that is great. Congratulations. And you're very welcome. It's always a pleasure, and it always brightens up my day to see that someone else has gotten through the process successfully. So good luck on the rest of it, on waiting on your permanent residence to come and to close that chapter. Tamara Davidson. So I do this live so often that it's hard. I know a few people, and if you want to jog my memory, if there was something that we talked about in the live, you can definitely feel free to do that. So keep putting those questions in the comments. I am here to answer your questions. So I'm a green card holder. Can my fiance get EAD if we get married in the USA? So now that is a great question, and I'm glad that you brought this up, because this is a topic that I was going to touch on. Now we know who qualifies through a green card holder. The next thing is, now you said fiance. I'm assuming when you get married, you're wondering if your fiance who is out of status can then apply for an employment authorization. And unfortunately, they would not be able to qualify if they're already out of status. So if they are in status, they can continue. And if they can continue within legal status for the duration of the process, which will take about 2 years, then they may very well qualify for adjustment of status. But in the case that a spouse of a green card holder has fallen out of status, they will need to pursue what's called the waiver option. So in this case, they would not, unless they qualify in some other way for the employment authorization, they would not qualify just being based on their marriage to a green card holder. Now, your fiance turned spouse you could still move forward. Assuming that you qualify in every other way to apply for permanent residence But what you would have to do if your spouse is here without status, it is likely they'll have to pursue the waiver option. And the waiver option is going to depend on the evidence showing your extreme hardship as the green card holder spouse. If they do get approved for this waiver, it's very important to prepare a good waiver, and that's what I do for my clients. Then at that point, it will allow them to leave the country and attend the interview at the embassy, as long as there are no other disqualifying issues in their background. So thanks so much for the good vibes. Thanks so much. I appreciate it. So let us continue. So do you fight detainee cases? So yes. However, whether I take your case or not is going to depend on what the facts are, and whether you would qualify for any form of relief. Call, schedule a consultation, and we can talk more. So my fiance is B1, B2. So saving the children, schedule a consultation. So important that you get detailed legal advice before you file anything. Because even though your fiance is a B1, B2, remember that the B1, B2 is very temporary, meaning that the maximum amount of time that a B1, B2 person can get coming in is about maximum 6 months if they're lucky. And the adjustment of status process lasts for 24 months. And so what that means is that at some point of the adjustment of status process, that B1 or B2 status is going to end. And it's going to end within months versus the adjustment of status process going on for 24 months, 18 to 24 months. And so at that point, if your fiance turned spouse, because remember, green card holders can't file for their fiance, you'd have to get married. And at that point that they are in the process and they overstay over 180 days, then they are at a point of no return and they'll accrue unlawful presence. That's the point that you need a waiver. So saving the children 2021, very important you get advice because it's going into complex territory and you want to make sure that you are fully knowledgeable about the process and that you know what you're getting into and that you get representation through the process. So, okay, I have a son in the USA. Is there any chance? How can I stay in the USA? No family, no mother. So, Tamara Davidson, in the case that you do have this son in the US, unfortunately, having a child under the age of 21 is not going to automatically qualify you for status in the United States. That's the frustrating part. So it really is going to depend on what other qualifying factors you have. And that's where you have to schedule the consultation. But if you have no family, U.S. citizen or legal permanent resident spouse, parent, then your options are limited in the family field. You would have to wait for your child to be 21, your U.S. citizen child to be 21. And if you are here in the U.S. and you've now overstayed your time, you also have limited options in terms of finding an employer who can sponsor you. Just because once you've accrued unlawful presence, you will need that waiver. So the waiver I was talking about, you would need that waiver. And so if you don't have a U.S. citizen or legal permanent resident spouse or parent to qualify for you for that waiver, then you would be stuck. But I never like to say that it's impossible because I don't know all your circumstances. Keep in mind that I am giving you general information. I'm not your attorney. I'm not giving personal legal advice. And so in order to do that, I'll need to sit down with you in a consultation to evaluate your full circumstances to determine whether there are other forms of relief available based on what you've been through since you've been here. So let's see. So I'm not jumping the gun, but will I be able to go to the UK after I get my green card? So CAMS 356, you would be free to travel. Keep in mind though that you would have to apply for a visa in the UK. I'm not a UK attorney, but having a green card is not going to give you the same benefits as US citizens, where US citizens can travel around the world to many countries without having a visa, including the UK. With green card holders, you're still gonna have to make sure that the country that you're the citizen of, whether that country is required to get a visa. So still look into that to make sure. But it definitely, getting your green card definitely makes it easier because now you can travel without that fear. And usually during the adjustment of status process, you can't travel. Will I have to be fully vaccinated for my spouse who is a green card holder to file for me? So Angeli, yes. So at this point, if your green card holder spouse files for you and you go through the process, then at the point that you're doing the medical examination, you are going to be required to show that you've been vaccinated. At that point that you show that you have been vaccinated, that is when the physician would approve your would approve the vaccination requirements. Now there are some exemptions based on thanks so much for the love. I appreciate it and the good vibes. Thanks so much, and that's why I come every night. So there are some exemptions. So the exemptions would be, for example, if the doctor says that it's inappropriate, the doctor looks over your records, see that it's inappropriate for you because maybe medical history. If you have, and there are religious exemptions as well, but that you'd have to actively file for. It's a religious waiver. And so if you need any assistance with that, you know where to find me. Just go to the link in my bio. It'll take you to the website where you can contact the firm and schedule a consultation. If I was filed for under unmarried child, but my divorce didn't come through till this year. So at the time that, so if you were filed for as an unmarried child, but your divorce didn't come through till this year, at the interview, you will have to show that you are indeed unmarried to be able to qualify for that, for the green card, because that is one of the qualifying factors, is that you have to be unmarried at the time that you're going to be getting that immigrant visa. Now, another thing though that I want to point out is that your case is going maybe a little more complex, because remember, if your petition was approved, your I-130 petition was approved, it was actually approved based on information you gave them when you were married. And so Akila, get legal advice, because that could spell trouble for you. Now, while I'm not your attorney, I can't give you personal legal advice. What I can tell you generally is that if you apply for the I-130 petition and you put that you were unmarried, that you were not married, and you were in fact married, then that could be construed as misrepresentation. And that is a serious charge. So you don't want to, just because when a decision came through, they made that decision based on those facts. So that you're heading into complex territory, you want to make sure you're protected, you're covered. So schedule a consultation. We can talk more about your situation and make sure you're okay. I send off my wife documents 1 year now, saying it's at the National Visa Center. One now still don't. So yes, so it is taking a long time at the National Visa Center, Jerome. You're not the only one, unfortunately. Both my kids got US visa and I was denied twice. What may be the reason for that? So the lack of ties. So if you can't show ties to your home country, sufficient ties to your home country, they're gonna deny. 1 year now, still don't hear anything back. So make sure you check the National Visa Center. Make sure you're submitting all the information that they need to see, and then just check your status and see if there's anything that can be done on your end to move things along. Hi, how long does adjustment of status take if your I-130 got approved before adjusting? So you're still looking at about 12 months to 24 months to go through the entire adjustment of status process. What is the timeline for I-130 alien relative file when someone files on January 2015 Indian? So it's going to depend, Jay Hind, on what the relationship is. So is it as a sibling? Is it a parent? Is a U.S. citizen parent filing for their married child? That's what is going to determine the length of time. My fiance, as resident in the U.S., how can he apply for us? So fiance, so green card holder, a green card holder fiance can't file for you. You would have to get married for a green card holder to apply for you. Green card holders can only apply for their spouse and their children, unmarried children. My sister's in detention center. She completed her process like fingerprints and stuff. She's waiting for a judge to grant her asylum. How long will the process take? So it depends on the court. Different courts have different processing times. It could be a matter of months to even years, unfortunately. So if your sister needs assistance, she doesn't already have an attorney, definitely I can assist if she needs it. My divorce came before the I-130 was approved. Okay. Now, Akila, I can't give you any specific legal advice. However, at the time that you entered that information, you were married. And so that may be a sticky point that you would want to make sure that you clarify. Can my fiance apply for me for the U.S.? He's as resident. So no, green card holders can't file for their fiance. Only U.S. citizens can file for their fiance to get the fiance visa to come here on the 90-day visa and then get married within those 90 days and then adjust status. So great questions so far. What can I do if I can't find my green card? So if you can't find your green card, you'll need to apply for a replacement. Usually that is done through the I-90 form. That can be done online, and it can be done through a paper form. If you need assistance with that, Stacey Eddy, you can always call and schedule a consultation. We'll talk more about it and then get started right away. So I am talking about residents applying for their relatives, and qualifying relatives are going to be the spouse and children, either they have to be unmarried, but they can be under 21 and over 21. Right now is a good time for residents to apply for their spouse or children under 21 and unmarried, because there is no wait list right now for an immigrant visa number. And if you're wondering why does the process have to take so long for certain categories, it's because of this. It's because of waiting for the immigrant visa number. Now, this immigrant visa number does not apply to immediate relatives of U.S. citizens. Immediate relatives of U.S. citizens are going to be the spouse of a U.S. citizen, the parent of a U.S. citizen who is 21 and up, or the son or daughter of a U.S. citizen who is under 21 and unmarried. They don't have to wait, and that's why their process takes shorter. Shorter right now is 18 to 24 months. Right now, because there's no wait list for an immigrant visa number, that means that spouses of green card holders and children under 21 and unmarried of green card holders are on the same processing time as they would be if they were relatives of U.S. citizens. So that is one thing that you should know. And therefore you need to make sure you apply. Make sure that you apply, but first, before you apply now, take action now, get legal advice. Because as I touched on before, if your spouse is here in the United States or your children are here in the United States without status, then that is going to be a different process. Now, not because they qualify for permanent residence means that they are going to qualify for adjustment of status. Adjustment of status is the process of applying for permanent residence while you're in the United States. Now, generally you have to maintain legal status to adjust in the US, unless you meet an exception. But in this case where you are sponsoring your relative, they would not fall under an exception, and so you would have to go through the waiver process. The waiver process basically fixes their status, so it gives forgiveness for the overstay, for the unlawful presence, and then if all being well, that waiver is approved, they can then travel to their home country to attend the final interview. Your relatives can wait in the US while the waiver is pending, wait in the US while the petition is pending, and then when the interview is scheduled, they can travel down for the interview and then come back about 3 weeks afterwards. Now, the reason the waiver is so important is because if you leave the country without a waiver and you have accrued unlawful presence for over 180 days, it will bar you from the United States for at least 3 years. So at that point, that means that you will not be able to get a green card. You will not be able to come back, no visa, no re-entry. And so the waiver fixes that situation. The officer will not use the overstay or unlawful presence against you, and that bar will no longer apply. And so what that means is that you can travel to the interview. The officer is going to disregard the fact that you have accrued unlawful presence, and then as long as you have no other disqualifying issues in your background, then the officer would be able to approve you, and you would get your immigrant visa within a few weeks and be able to travel back. So citizen husband can file for in-laws when wife is on green card. So no, not even a US citizen can file for their in-laws in this case. So no in-laws, no green card holder can apply for their in-laws, and a citizen can't apply for their in-laws. All right. So keep those questions coming. I am going through the topic of applying for your spouse and your children. So filing is going on for 3 years. So Danielle Robinson, it depends on what filing you're waiting on, but it can actually be even longer than that, just depending. So if you are a son or daughter, you're over 21 and you're unmarried of a US citizen, that's 6 to 7 years right now. If you're the child of a green card holder, so your wife. So at this point, Danielle Robinson, processing times are longer for sure, and it's very frustrating. So if you need help, as you said you need help, call, schedule a consultation. We can go through it, your facts, and see if there's anything that can be done. Captain Morgan, thanks for the follow. So why Danielle Robinson? So it could be any number of reasons. I don't know if you're in the US or your spouse is outside of the US, but COVID was a big factor in the whole thing. So when COVID happened, it pushed back a lot of case processing times. And then remember, before that, there was the previous administration that was anti-immigrant. And so in this case, with the anti-immigrant tactics, they created a system that was not conducive to faster processing times to begin with. Then COVID made it worse. So, okay, so Danielle, yeah, so you're in Jamaica and wife. So I would say the processing times, COVID, and then what's going on at the National Visa Center. Have you been keeping up with your case at the National Visa Center to make sure that you're meeting all their requirements? So if I have 2 kids over here, they are here without no papers, but they are going to school here. So Tamara Davidson, unfortunately, going to school is not going to necessarily qualify them for status, unfortunately. Hi there in Sierra Leone. Thanks for tuning in. So yeah, so that alone, going to school isn't going to qualify them. Schools here don't penalize children who are undocumented. They still allow them to attend school, and that's why they are still able to go to school and function even though they're undocumented. So where is the National Visa Center located? So the National Visa Center is, they don't process cases, they usually process cases that are going through the consular processing. So they're like the middleman for processes outside of the United States that are going to take place at the embassies. So it's not a service center for local or adjustment of status cases in the U.S. Also, kid. Also, you want to restart school in the U.S. So there's always a student visa, and I noticed you said restart, so that tells me you were going to school before. So if you have any issues, definitely call, schedule a consultation. So Tamara Davidson, that is where the consultation is going to be helpful to you. Because it is in the consultation. Remember that I don't know your facts and I'm not your attorney. So I wouldn't be able to advise you personally on what you can do until I know all your full facts. So all I know here is that your children are going to school, they're undocumented, but they would still have to qualify in some way to get their papers, and that's what I would have to figure out. What's your background? How would they qualify? So if someone applied from Vermont Center but receipt got from National Visa Center, is that bad? So Jay Hind, usually the National Visa Center is involved once the petition has been approved. So that is something you'll have to speak with me in a consultation about to determine where you are in your process, because I don't know where you are in your process, what's going on, has your I-130 been approved, and so forth. So Danielle, let's see. So Danielle Robinson, I would not be able to predict whether it's going to come through any sooner. But if you call, schedule a consultation, we can talk more about what the situation is. Usually when it gets to the National Visa Center, the National Visa Center gets in touch with you and they will request specific documents to be able to facilitate the interview. So they will not schedule your interview until they receive everything. And so you want to make sure that you are on top of that. They usually send messages if they rejected documents or they have additional requests. They will send messages to you, so you want to make sure that you keep in contact with them, and also keep in mind that if you don't keep in touch with them and they were the ones that asked you for information, then at that point you could possibly have your case closed. So you want to make sure that you keep up on your case. Tamara, I'm looking forward to speaking with you to see what we can do here. So interview at the embassy. So I am Danielle, I noticed you said barbecue, so I think that was a typo, of course, but let me know what you meant by that. So interview at the embassy. So I did 2 interviews at the embassy. So Danielle, that if you went through the interview, you did 2 interviews, then that's indicating that something is going on and you need help. So you said you need help. You definitely need help at this point. It may be in administrative processing because they've found something in your background or in your spouse's background. So you want to see if, so me first and my wife. So you definitely want to get legal assistance to see what's going on and what options. So what is the national, so it's the Benefits Center, so National Benefits Center. And all right, so keep those questions coming. Okay, so Danielle, it seems like your case is going to be more complex because once you've gotten to the interview and they have asked you questions and they still haven't made a decision, there's something additional going on, and you want to get to the root of that. So it may be that they're not convinced it's a bona fide marriage. It may be that they found something in your background. It may be that something is missing that they're requesting. And so that's where the consultation is very important. Now, I am going to finish up the topic here of applying for permanent residence for your spouse or your child if you are a permanent resident. So as I mentioned before, if you are a permanent resident and you have your spouse here, you have your child here, and they are out of status, get legal advice. That is the point of this whole live for me, is to get that message across to you, because it's not going to be as simple as just applying for adjustment of status if they're out of status. There is a waiver process that's required to be able to complete the process successfully, and they would not be able to qualify for adjustment of status here in the US. That means to stay in the US and apply, but there is still an option to go on and get permanent residence once they apply for the waiver. And this is called unlawful presence waiver. That's what you need to schedule this consultation with me to make sure that your relatives qualify for this. And you need to do it as soon as possible. If you filed or if you're about to file, you need to pause and get legal advice about what you need to do. Now, I am going to head over to Instagram, where I do lives at 9:30 p.m. Eastern time every night as well. Most of my content is on Instagram, so you are free to follow me on Instagram, where you can get more updates, more information. I usually promote my lives here on TikTok, but most of my content lives on Instagram. It's The Immigration Attorney. So my consultation fee is $150 for up to an hour. It is well worth your time and money, because you walk out knowing your options, knowing how to approach your situation. You know whether you had better options, and you can have me as your attorney to represent you through the process. I represent clients in all 50 states. I'm not limited by borders, not limited by state lines. I represent clients all over the world and the United States, as long as it's a US immigration issue. So go ahead and follow me. You can hop on over right now to Instagram. There's a button in the link that leads to Instagram. If that doesn't work, because it works for me, but it doesn't necessarily work for others. So if that's not the case, just go to Instagram and type in The Immigration Attorney, all in one, and you will find me. Follow me and then hop on live with me right now. If you can't join me on Instagram, I'm going to be here tomorrow at 9 p.m. Eastern, or if you want personal legal advice, you can call and schedule a consultation where we can talk more about your situation. So Christina, I'm located in Boca Raton, Florida, but that's where I'm based. I represent clients all over the country, and I offer phone, video consultations, and I'm very experienced with working with my clients remotely once I have to represent them through this process. So I'll see you tomorrow at 9 p.m. or I'll see you on Instagram in a minute, or I'll speak with you in a consultation. Thanks, everyone. If you want to learn more about me or schedule a consultation, go to the link in my bio and go to the website. It'll take you to the website where you'll see the different ways to get in touch. There is a scheduling coordinator who's available right now up until 11 p.m. to answer your call and schedule your consultation. Have a good night. I'll see you on Instagram in a minute, or tomorrow at 9 p.m. Eastern.